Good afternoon and welcome to Disability Rights University. Today's session is called Assistive Technology and Students with Disabilities. Our presenter today is one of Disability Rights South Carolina's attorneys, Amanda Hess, and I will let her introduce herself in just a minute. A few things to go over with you before we get started. We are recording this session today and we will be putting it on YouTube at a later date for reference. We have muted all participants and we will wait to take a few questions at the end of the session. We'll leave about 15 minutes for Q&A. At that time, you can put your questions in the chat and I will read them later, or you can raise your hands. We do ask that you do not put any personal identifying information into the Q&A and instead leave your questions very general, since they will be going onto YouTube. And if you'll go to the next slide, Patrice, we just wanted to go ahead and share with you our next and our last session for 2024 is on September 18th. It is called Medicaid Waivers and Waiver Case Management. And this will be also during the lunch hour from 12 to 1. So we hope you will join us for that information then. So we're going to go ahead and get started today. And Amanda, I will let you take over. Thank you so much.
Thanks, Maggie. As Maggie said, my name's Amanda Hess. I'm one of the senior attorneys here at Disability Rights South Carolina. And I just want to thank you all for attending today's session. As Maggie mentioned, we're going to be discussing assistive technology and students with disabilities today. And this presentation will be specific to South Carolina. And if we could go to the next slide. So if any of you want a copy of this presentation, here's a QR code. We'll just take a moment to give you an opportunity to scan that if you wish. Okay, if we could go to the next slide, please. So for what you can expect during today's session, I'm going to start by giving you a little bit of background about Disability Rights South Carolina. We're also known by the acronym DRSC. And then before we start talking about assistive technology, I'm going to review some concepts from the Individuals with Disabilities Education Act. And then we'll move on to assistive technology and services under the Individuals with Disabilities Education Act. And we'll finish up with just a little bit about Section 504 of the Rehabilitation Act. But first, we're going to start by talking about Disability Rights South Carolina. Next slide. This slide is our mission. And our mission is to protect the legal, civil, and human rights of people with disabilities in South Carolina. We want to enable individuals to advocate for themselves. We also advocate on individuals' behalf when they've been discriminated against or denied a service to which they're entitled. We educate the public, stakeholders, and policymakers about laws that protect individuals with disabilities. And we promote policies and services that advance those rights and interests. Next slide, please. This slide contains a little bit more information about Disability Rights South Carolina. We are a nonprofit providing services statewide. We do not charge for our services. Disability Rights South Carolina is independent of all agencies that provide treatment or other services to people with disabilities. DRSC is the Protection and Advocacy Agency for South Carolina. Those also go by the acronym P&As. And as the P&A for South Carolina, Disability Rights South Carolina is mandated by state and federal law to protect the rights of people with disabilities in South Carolina. There are 57 P&As nationwide in all states, districts, and territories. And please know that we work in a lot of other areas beyond the education of students with disabilities. We do have a website that has more information about DRSC and what we do, and it has lots of resources on it. That and our contact information is on a slide towards the end of this presentation that we'll review. And some of our services can include information and referral, technical assistance, self-advocacy assistance, direct assistance on behalf of individuals with disabilities, public policy work, and DRSC has the authority to monitor institutions and communities, facilities that serve people with disabilities, and when necessary, DRSC can conduct investigations into issues of abuse, neglect, and exploitation of individuals with disabilities. All right, so as this slide indicates, now we're going to start by discussing some concepts that I thought may be helpful to review from the Individuals with Disabilities Education Act. That's also known as IDEA. And IDEA is the federal law that provides for special education and related services to eligible students through individualized education programs. Those are also known as IEPs. Now, I'm not going to cover all concepts and terms under IDEA today. That would take a long time. But I did pick a few that I think can be helpful to know the name and some background information about before we start discussing assistive technology under IDEA. Being aware of these terms and how they can be related to assistive technology and other areas of education can help make you more informed as you attend IEP meetings and communicate with school district staff. And I think it's just also helpful to know the lingo under IDEA. Next slide, please. First, we're going to start with the IEP team itself. This is the team that develops, reviews, and updates the IEP. IDEA provides for the makeup of the IEP team. The IEP team will include the parent. If the student is age 18, which is the age of majority in South Carolina, or older, the student will be invited. At least one regular education teacher if the child will or might participate in regular education. A special education teacher, a school district representative, and this is someone who's qualified to provide or supervise special education, is familiar with the general education curriculum, and is familiar with school district resources. Someone who can interpret evaluation results. The example on the slide is a school psychologist, for instance. The child whenever appropriate. Note here that if the child is age 13, that's considered transition age. So if transition is going to be discussed in IEP meetings, the child has to be invited. And we're going to talk about that shortly. And anyone else the parent or school district chooses that has knowledge or special expertise about the child. Next slide. It's really important for parents to be aware of their right to participation in the IEP process. So we're going to talk about parent participation. As we discussed on the previous slide, parents are members of the student's IEP team. School districts have to take steps to ensure that parents have the opportunity to participate at IEP meetings. So school districts have to notify parents early enough to schedule IEP meetings at agreed upon time and place. A parent will be sent a notice of meeting, and that should be reviewed carefully. It should include the purpose of the meeting, along with the time and the location of the meeting, and who's expected to attend the meeting. If you get that notice and the date and time of the meeting isn't going to work for you, it's okay to let the school district know that, and then work with the school district to find a date and time that will work. Do not ignore meeting requests. This is your opportunity to participate, ask questions, and provide input into the IEP process. And that includes input about assistive technology. Parents can request IEP meetings, and school districts should work with the parent on how they're going to participate in the meeting. That could be meeting in person, it could be participating virtually or by phone. Keep in mind that school districts also need to ensure that parents understand IEP meetings. So this could include arranging for an interpreter if it's needed. Just let your district contact know if you need any accommodations for the IEP meeting. And just a reminder that parents should be provided with a copy of their student's IEP. Next slide. Prior written notice, and that's also known as PWN, is a very important document in special education. A PWN is a written notice that the school district must provide whenever the district proposes to initiate, change, or refuse to initiate or change the identification, evaluation, educational placement, or provision of free, appropriate public education of the student. IDEA outlines the content areas that have to be contained in the prior written notice. So it should include a description of the action proposed or refused, an explanation of the reason for the proposal or refusal, other options considered, the information used, and other relevant factors for the proposal or the refusal. A PWN has to be written in an understandable language, and it should be provided in the parent's native language. There will also be resources listed on the PWN that parents can follow up on if they want. A common misunderstanding is that prior written notice should be provided before an IEP meeting. Because it discusses decisions made at an IEP meeting, a PWN is provided to the parent after the meeting, but before the change takes place. This is to give parents time to consider the change before it's implemented by the school district. And if you're interested in learning more about prior written notice, you can find that on DRSC's Educational Resources website. Next slide. Free appropriate public education, that's also known as a FAPE, F-A-P-E. This is an entitlement for all students who are eligible for an IEP. And it is special education and that specially designed instruction and related services that are provided through an appropriately developed IEP at no cost to the student. Next slide. FAPE is something that's been reviewed in the Supreme Court, with the most recent decision being the Andrew F. matter, and that was decided in 2017. This is a very important decision in the world of IDEA and helps us to understand the FAPE standard. And I just pulled a couple of important concepts from this case, which is on this slide. And that is an IEP should be reasonably calculated for the student to make appropriate progress in light of their circumstances, and that the student should be given the chance to meet challenging objectives. If you're interested in more information about Andrew F. and FAPE, there's a helpful U.S. Department of Education question and answer on this decision. It's dated December 7th, 2017, and that can be found on the link on this website. Next slide, please. Least restrictive environment. This is also known by LRE. Least restrictive environment is that students should be educated to the maximum extent appropriate with their non-disabled peers. Now keep in mind, this is a presumption, not a mandate. So each student's LRE and placement is going to be based on their IEP, and after the IEP team has considered the full range of supplementary aids and services. And we're going to talk about those on the next slide. There should be a continuum of alternative placements, and LRE also includes non-academic and extracurricular services. And DRSC also has a resource on least restrictive environment on its Education Resources website. Next slide. And now we're going to talk about supplementary aids and services. These are determined by the student's IEP team. It's aids, services, and other supports that enable a child with a disability to be educated to the maximum extent appropriate with children without disabilities. So it could be assistive technology. These are provided in regular education classes, other education-related settings, extracurricular and non-academic settings. Next slide. Related services. Related services are developmental, transportation, corrective, and other support services that an IEP team determines a student with an IEP needs to benefit from special education. Related services can include speech language services, interpreter services, psychological services, physical therapy, occupational therapy, orientation and mobility, school health services, counseling services, and parent training. And as noted on this slide, it excludes surgically implanted medical devices. DRSC also has a resource on related services that can be found on its education website. Next slide, please. Now we're going to talk about independent educational evaluations. This is also known as IEEs. Now, evaluations can and are done through school districts. An independent educational evaluation is done by an independent qualified examiner who is not connected to the school district. IEEs can come up if there's a disagreement with a school district evaluation. I am going to discuss two types of independent educational evaluations. The first type of independent evaluation I'm going to discuss is a parent requesting an independent educational evaluation at public expense if the parent disagrees with a school district evaluation. A parent can ask for one IEE at public expense each time a district does an evaluation that the parent is concerned about. Once the request for an IEE at public expense is made, the district must provide the IEE, or it can request due process to show that its evaluation was appropriate. If the school district is going to provide the IEE at public expense, the district then provides information to the parent on where to obtain an IEE and the criteria the school district uses for an evaluation. With an IEE at public expense, the team has to consider the evaluation, but ultimately decisions about IEP services are IEP team decisions. The other type of IEE I'm going to discuss is that a parent can obtain an independent evaluation at their own expense. This can be done at any time, and it is not connected to the IEP process. This could provide a parent with an outside perspective if there are questions or concerns that the parent wants to look into privately. If the parent decides that this information will be shared with the IEP team has to consider it, but ultimately decisions about IEP services are IEP team decisions. Next slide, please. And the last concept I'm going to discuss in this section is transition. This is a very important area, and assistive technology can definitely come up during this process. Transition is a requirement in IDEA. It is all about preparing students with IEPs for life after school, whatever that may be. It facilitates movement from school to areas including post-secondary and continuing education, employment, and living as independently as possible. Transition actually begins earlier in South Carolina than it does in IDEA. In South Carolina, transition planning begins with the first IEP in effect when the student turns age 13. At that time, the IEP team needs to assess the student's needs, and it will develop transition goals. In order to do that, age-appropriate assessments and evaluations, both formal and informal, should take place. All of this information will be used for the IEP team to develop measurable post-secondary goals. These goals should be reviewed and updated at least annually. The IEP will also have transition services that are needed to help the student reach those post-secondary goals on their IEP. Transition services are a coordinated set of activities to help prepare students for life after school and are based on the child's individualized needs. And transition services can include instruction, related services, community experiences, like job experiences, development of employment objectives, daily living skills, and it could be a functional vocational evaluation. When the IEP team is discussing transition, the students should be involved and invited to IEP meetings. If the student is not able to attend the IEP meeting, then the team has to find other ways to ensure that the student's interests and preferences are discussed and considered. And finally, outside agencies who may provide or pay for transition services should be invited to IEP meetings with the consent of the parent or the adult student. This could be agencies like South Carolina Vocational Rehabilitation Department or South Carolina Commission for the Blind. I definitely encourage you to learn more about transition services. And if you do want more information, DRSC does have a resource on transition services on its education website. Next slide, please. All right, now that we've got some background on IDEA terms, we're going to move into assistive technology. And throughout this part of the presentation, I'm also going to refer to assistive technology as AT. In this section, we're specifically discussing assistive technology and the Individuals with Disabilities Education Act. Next slide. Under the IDEA, an AT device is defined as any item, piece of equipment, or product system that can be obtained commercially off the shelf, or it can be customized or modified, and it is used to increase, maintain, or improve the functional capabilities of a child with a disability. An AT device does not include surgically implanted medical devices or replacing them. So when you really think about it, this is a really broad definition. Next slide. And on this slide are some examples of AT devices: a graphic organizer, pencil grip, visual schedule, magnification devices, calculator, accessible desk or chair, FM system, augmentative and alternative communication devices and applications, screen magnifier, laptop, tablet, and applications for reading, writing, and audiobooks. This is not an exhaustive list, and as you can imagine, this list could go on and on and on. You'll also note that AT devices can be high-tech, like a communication device, or it can be low-tech, like a pencil grip. Next slide. IDEA also defines assistive technology services. And an AT service is any service that helps to select, acquire, or use an assistive technology device. Next slide, please. And IDEA has a list of AT services, and that can include the evaluation of the student's needs for assistive technology. That can include a functional evaluation. Acquiring AT, so that could be purchasing it or leasing it. Selecting, designing, fitting, customizing, or adapting assistive technology. The maintenance of assistive technology or the repair or replacement of it. It could also be coordinating with other services or therapies. So for a student that has physical therapy or occupational therapy, making sure that assistive technology is coordinated with that. That could be a service. Some important AT services to be aware of, if they're needed, are training and or technical assistance for the child who's using the AT device, or the family if appropriate. And staff involved with the student can also get training or technical assistance on AT when needed. So AT services are also pretty broad. Next slide. We've talked about what AT devices are and what AT services are under IDEA. So now we're going to move into AT and the IEP process. AT devices and services are IEP team decisions that, if determined are needed, are going to be reflected on the student's IEP. So it's definitely important to talk about this process. IEP teams have to consider whether the student needs assistive technology devices and or services when the student's IEP is developed, each time the IEP is reviewed and revised as well. So AT discussions and whether there is a need for AT should be done at IEP meetings. Some things to think about. Does the student need AT to progress on their IEP goals? Does the student need AT as a supplementary service or a related service? Does the student need AT to access their education? Does the student need AT to be in their least restrictive environment? Are there behavioral concerns such that AT should be considered? This sometimes comes up in the context of communication, for instance. Does the student need AT as part of transition? So you see that some of those terms we discussed earlier definitely come up in assistive technology. These are just a few ways that AT can come up in the IEP process. Anyone can raise this to the IEP team. It could be the parent or the student or someone on the school district staff. It might come up in a school district evaluation or an independent evaluation. Any decisions about AT devices and services at IEP meetings should also be documented on the prior written notice from that meeting. Next slide, please. AT and the IEP team. We discussed members of the IEP team earlier. When assistive technology is going to be discussed at an IEP meeting, there should be someone familiar with AT devices and services at that meeting. Some school districts have AT specialists or someone with more knowledge about AT on staff. And you can check with your school district if assistive technology is going to be raised. If at an IEP meeting AT comes up and the team is not familiar with AT devices or services, then the team can seek out others with knowledge that can be involved with the team. Next slide. Determining the need for assistive technology. There can be different ways to determine a student's need for assistive technology devices and assistive technology services. This usually starts through discussions during the IEP meeting itself. The student's teacher raising a possible need based on observations in the classroom, or a parent asking if a student may need AT to help their child, such as with writing. Sometimes there's enough information at the IEP meeting to determine a student needs an AT device without the need to trial it or evaluate it. For instance, a teacher may suggest a graphic organizer for a student to help with reading comprehension based on data that was collected in the classroom. There could be enough information for the IEP team to determine the student needs that assistive technology and include it on their IEP. Sometimes the team will agree to conduct an informal trial of assistive technology to determine if a student needs an assistive technology device. For instance, if the team thinks a reading app will help a student based on needs discussed at the IEP meeting, but the team isn't sure if it will be a good fit, that could be trialed and then reviewed again at the next IEP meeting. Sometimes the need isn't clear, and a formal AT evaluation is agreed upon at the IEP meeting. In this instance, the school district will get the parent's consent to conduct the AT evaluation. Keep in mind that it may take time to evaluate the student. Sometimes that evaluation might include trials of AT and data collection on AT devices. You can ask about what to expect in the evaluation at the IEP meeting. Once the evaluation is done, it will be reviewed by the student's IEP team to determine any needed AT devices and/or any needed AT services. Keep in mind that the IEP team is determining in this process if a student needs AT and/or AT services for a free, appropriate public education. Next slide. Here are some considerations to think about when AT devices and AT services are being discussed during the IEP process and IEP meetings. What are the student's needs? AT should be individualized to the student. And in order to do that, there needs to be a discussion about the needs of the student and any areas that AT may be useful and/or needed. Does the IEP team have enough information to make a determination? Is a formal AT assessment needed? Do devices need to be trialed? Where is the student going to need the assistive technology? The IEP team should consider any needs the student has in the classroom as well as outside the classroom. So, for example, on the school bus or in extracurricular activities. Should AT be with the student at all times? For instance, if the student has a communication device. Having these discussions with the IEP team can clear up any confusion about AT device usage. Is there going to be any data collection? Is data going to be needed? Data is a really important part of the IEP process. What data is needed about the AT device and/or service, and how it will be collected should be discussed. This data could show whether the assistive technology is effective. And finally, are any AT services needed? I want to emphasize the importance of the IEP team to consider any needed AT services in this process. If an AT device is determined needed for the student, for instance, is training needed on the device by the student, the parent, the staff working with the student? If the student doesn't know how to use the device, then how effective will it be for that student? Next slide. AT and the IEP. Now we're talking about the IEP document itself. Once it is determined by the IEP team that a student needs an AT device and/or services for a free, appropriate public education, it must be included on the student's IEP. The level of detail on the IEP regarding AT devices and services is really going to depend on the assistive technology device and its usage. Some assistive technology is going to benefit from having more detail on the IEP. For instance, its need, when it will be used, how it will be used, where it will be used, the type of training on the device that's needed, if any. And some AT is not going to need a lot of detail and just may not need it. For instance, the use of a pencil grip when the student's writing. These determinations are going to be specific to the IEP team, but I think it's important to have these discussions. Again, having them could alleviate confusion about AT devices and services down the road. Next slide. AT and the IEP. We are continuing to talk about the IEP document in this slide. Assistive technology may be found in different places on the IEP document. Consideration of special factors. These are factors that all IEP teams have to consider, and assistive technology is one of them. I believe this is called special considerations on the new IEP format. AT could also be found in the student's goals. It could be a supplementary aid or service on the IEP, could also be a related service. It might be listed as an accommodation. For example, an FM system to help amplify a teacher's voice for the student, or a calculator. AT may also be indicated in the transition section of the IEP or in state and district assessment accommodation needs. Next slide. Let's discuss some things to keep in mind. Once the IEP team determines that a student needs assistive technology and/or services, then the school district has the obligation to provide the needed AT and AT services at no cost to the student. Assistive technology acquired by the school district belongs to the school district, not the student. A school district cannot base an AT denial on cost alone. A parent or a student may raise a preferred assistive technology device at an IEP meeting. School districts do not have to provide the preferred AT if there's another AT device that meets the student's needs in the context of IDEA. If needs change, the assistive technology is not a good fit, or there is assistive technology refusal by the student, then the IEP team should reconvene to review what is going on and evaluate that. For instance, if the student is refusing to use the assistive technology, the team should review that and try to determine why. Maybe the student needs further training on that device, or is there another way to address the assistive technology need? Next slide. AT at home. When an IEP team determines that a student needs assistive technology, I think it's important to discuss if the student's going to need that assistive technology device at home or not. AT devices can be brought home if the student will need to use it at home. For example, if a student has a laptop listed as an assistive technology device in their IEP, and the student needs that laptop to complete their homework at home, then there should be a discussion about the student bringing that assistive technology home. This should be discussed by the student's IEP team and addressed if it is needed. Finally, just another reminder that if a student is bringing an AT device home, there should be a discussion about whether the parent will need training or technical assistance on that device. If so, that should also be addressed by the student's IEP team. Next slide. AT and transition. We discussed transition earlier and how important this area is for transition age students. Consideration of assistive technology devices and services should also continue and occur during the transition process and planning. Once transition goals and services are determined, AT devices and services should be reviewed in light of any transition needs based on that student's IEP. For example, if a student is using a communication app, what is that going to look like during their transition services? In addition, new needs may arise during this process. For instance, if a student is doing community work experiences, are there any AT device or service needs during those experiences? If so, those should be addressed by the student's IEP team. Some other considerations can also include if the student plans to attend post-secondary education, so college, university, or a technical school, or pursue employment after school, will there be any AT needs for the IEP team to consider as part of transition planning? For example, is the student aware of how to address AT in those situations? That's something that could be discussed as part of transition. We talked earlier about outside agencies who may provide or pay for transition services, and that they should be invited to IEP meetings with the consent of the parent or the adult student. And this is another important consideration in the assistive technology context. There can be discussion about AT needs from the perspective of these agencies, including any role of the agency, responsibilities, under the provision of assistive technology. There might be evaluations of assistive technology or maybe providing AT services and AT devices. Finally, some of these agencies may still be involved with the student after school, and there may be after school AT considerations as well. Next slide. AT from home. This is the student's private AT. And I'm just going to briefly discuss this if the student wants to use their private AT at school. As we discussed earlier, AT needs are determined by the student's IEP team and are the responsibility of the school district. If the parent or student wants to use their private AT at school, this should be raised to the school district to discuss and address. And there's likely going to be some logistics that need to be discussed or worked out. And I've put a reference on this slide to Myth 18 from the U.S. Department of Education's Myths and Facts Surrounding Assistive Technology Devices and Services. This goes into more depth about this, and you'll find that on a website link later in this presentation, and I'll review that. Next slide. Now we're going to move on to parent assistive technology concerns in IDEA. Next slide. So concerns about assistive technology can definitely come up through the IEP process. This slide just has some examples: not considering the need for assistive technology, delays in starting device trials or evaluating AT, delays in providing AT. Keep in mind for delays in providing AT is that it might take longer for some assistive technology to be provided. For instance, if it has to be modified or customized for that student. And I encourage communication with your school district about this and looking at the reasonableness of the timing. And in this instance, the IEP team should determine what can be done in the meantime to address that student's needs until the AT can be provided. Inconsistent AT, so AT being provided one day, but not the next. Concerns about the appropriateness of the assistive technology device. Needed AT services not being addressed or occurring, for example, not considering the need for training for the student or staff or the parent. Next slide. And these are some ways that could be utilized to address the concerns. Could share the concerns with the special education department, for instance, talking to the special education director or coordinator. Requesting an IEP meeting to discuss the concerns. You could ask if the school district has an assistive technology specialist. We talked about independent evaluations earlier. And facilitated IEP meetings. That's a free and voluntary option in South Carolina that can be used for any IEP meeting. And it's a typical IEP meeting with an independent and trained facilitator. And there's a process to request this, and I'm going to go over a website that's got more information about facilitated IEPs and how they can be requested on the next slide. So if we could go to the next slide. And this slide contains formal dispute resolution, which includes mediation, state complaint that's got a 1-year time frame to file it, due process, which has a 2-year time frame to file it. I'm not going to go into detail about these because I provided a website address on this slide, which goes to the South Carolina Department of Education's Office of Special Education's Dispute Resolution Information website, which has information about these and facilitated IEPs that I mentioned on the previous slide. And it has details, requirements, and how to request these, including forms if you want to use the forms. Next slide. This slide has more information on IDEA and AT. The U.S. Department of Education's Myths and Facts Surrounding Assistive Technology Devices and Services is an excellent and really helpful resource. It's something that I looked at in anticipation of this presentation. And Disability Rights South Carolina has an AT and special education resource that can be found at the website on this slide. Next slide. Now we're going to change directions and talk about Section 504 of the Rehabilitation Act of 1973. This is another federal law that students with disabilities can fall under. And we're just going to briefly talk about Section 504. Next slide. Very generally, Section 504 prohibits discrimination based on disability by programs or activities that receive federal financial assistance. And all public schools get some form of federal financial assistance. For our purposes today, the U.S. Department of Education has promulgated regulations under Section 504, some specifically for elementary and post-secondary education. So just a little bit about 504 in this context. There's an initial evaluation, and for qualified students with a disability, evaluation should take place on a periodic basis or before a significant change in placement. So it's possible that AT could come up during one of those evaluations. Under Section 504, qualified students with disabilities are entitled to a free appropriate public education, but it's defined differently than what I went under when I reviewed FAPE under IDEA. Given the time for today, I have some resources about 504. So if you're interested in learning more about 504 and FAPE and evaluations, I'll make sure to review those resources and where you can find them. Just some notes here. You often hear the term 504 team and 504, and this is where that comes from. It's knowledgeable persons that develop the plan, and parents or guardians can be part of that 504 team. Next slide. Section 504 and assistive technology. So in the 504 context, assistive technology can be raised by the school district or the parent. As I mentioned before, it may come up in evaluation. And it can certainly be determined that a student needs assistive technology under Section 504, and that can absolutely be part of the student's 504 plan. And some of the suggestions I mentioned earlier, as far as asking about data or if details should be on that plan to help alleviate confusion and usage of AT down the road. Next slide. Here are some ways that Section 504 concerns could be addressed. You could ask to talk to the Section 504 coordinator. It may go by a different title in the school district. You could request a 504 meeting to discuss concerns. All school districts should have procedural safeguards under Section 504, and that should contain information about due process hearings. The U.S. Department of Education's Office for Civil Rights does have a complaint process. There's a 180-day time frame to do this. There is lots of information on the U.S. Department of Education's Office for Civil Rights website about complaints, the types of complaints that can be filed, how to file them, and the process. It even has their case processing manual on it. And DRSC also has a resource about 504. And finally, a lawsuit could be looked into. Next slide. As I mentioned, I did provide resources about Section 504. Here are a couple of resources that provide general information. So if you're interested in looking into more about 504, the frequently asked questions about Section 504 and the education of students with disabilities, and a U.S. Department of Education Office for Civil Rights Parent and Educator Resource Guide to Section 504 in public elementary and secondary schools. Next slide. And we're just going to finish up this presentation with just a couple more general resources. So if you could go to the next slide. Here's some general assistive technology information. Disability Rights South Carolina does have an assistive technology website. That's the first one on this slide. And the second website is to the South Carolina Assistive Technology Program. I encourage you to review this website. It's a great resource in South Carolina regarding assistive technology. I recently looked at this website, and there can be device demonstrations to help inform individuals about AT options. There's a device loan program, an equipment reuse service, and they also offer trainings and workshops. For current information about the South Carolina Assistive Technology Program or for questions, please contact that program directly or look at their website. Next slide. Here's information for Disability Rights South Carolina. We do have an intake process if anyone's ever seeking assistance from us. The helpline is on here, as well as the TTY number. We also have a general information email. And finally, our website. Earlier in the presentation, I mentioned that we've got a lot of other resources and that they can be found on our website. This goes to our main website, and there's an option for resources from our main website, and then you can pick the topic area. Next slide. And if you're interested in giving us feedback on this presentation, you can scan this QR code, and that will take you to a survey. All right, if we can go to the last slide. I just want to thank you all for your time today. I hope you found this presentation helpful, and we have some time for questions. I just want to remind you, please do not ask specific questions. Please ask general questions because this is a recorded presentation that will be posted.
You can put those questions in the chat box or raise your hand at this time. Also a note, I did put a link to the PowerPoint in the chat box just because there are so many links within the PowerPoint for resources that you might want.
Thanks, Maggie. I appreciate you putting that link in. I always try to provide a lot of resources. There's a lot of great information out there that can be really helpful in this process.
We've gotten a couple thank yous. We have not gotten any questions. I think you were very detailed, Amanda, so we appreciate you taking the time to give us this presentation today. As we discussed earlier, our next session will be September 18th on Medicaid waivers and waiver case management. If you're interested in joining us, we would love to have you. Thank you very much for taking your time and spending it with us today. That will be all we have. Thank you so much, and bye-bye.
Thank you. Bye.